Let us say that a Filipino was validly married to another Filipino citizen in the Philippines. He subsequently divorced her in the United States. He then remarried in the US. What is the legal status of the divorce and remarriage? The divorce and remarriage are invalid under Philippine law. The predominantly Catholic Philippines is, other than the Vatican, the only country in the world which has no general divorce law. Divorce is not allowed in the Philippines except in the case of Muslim marriages. The divorce of a Filipino obtained abroad may be recognized under Philippine law, but only if it is secured between a Filipino and a foreign citizen. A divorce secured by a Filipino married to another Filipino shall not be recognized in the Philippines. The reckoning point is not the citizenship of the parties at the time of the celebration of the marriage, but their citizenship at the time a valid divorce is obtained abroad by the alien spouse capacitating the latter to remarry. The Supreme Court has been categorical in affirming this principle. Quote, "An absolute divorce secured by a Filipino married to another Filipino is contrary to our concept of public policy and morality and shall not be recognized in this jurisdiction." Thus, a divorce obtained overseas by a Filipino man from a Filipino woman is invalid under Philippine civil law. For the divorce to have been legally recognizable in the Philippines, one of the parties must have changed nationality before the divorce was granted. Since both spouses were Filipino citizens at the time of the divorce was invalid and cannot be recognized under Philippine law. Therefore, that first marriage had not been dissolved when the second marriage took place. Because the divorce was invalid, the subsequent marriage was bigamous and thus invalid. The family code provides that a bigamous marriage is null and void. The sole exception from this nullity is in the case of the reappearance of a former spouse whose presumptive death had previously been judicially declared. Thus, if a Filipino man obtained an invalid divorce from a Filipino wife and then remarried, the subsequent marriage would be invalid under Philippine civil law because a marriage contracted by any person during the subsistence of a previous marriage is null and void. It makes no difference if the Filipino subsequent marriage was valid in the foreign country in which it was celebrated. A subsequent marriage contracted by a Filipino citizen overseas, even if valid abroad, will not be recognized in the Philippines. This is because the Philippines asserts extraterritorial jurisdiction over Filipino citizens, even though living abroad, with regard to family rights and duties or to status, condition, and legal capacity under Article 15 of the Civil Code. These very principles were reaffirmed by the Supreme Court in a disbarment case concerning a Filipino lawyer who obtained a foreign divorce from his Filipino wife and then remarried in the United States. The lawyer was disbarred when he obtained a divorce from the Dominican Republic, even though he and his wife were both Filipino citizens at the time. As a lawyer, he well knew that the subsequent marriage he obtained was void. The Supreme Court disbarred him for a blatant and purposeful disregard of our laws on marriage. All this goes back to show that under present laws, a divorce obtained abroad by a Filipino from another Filipino will not be recognized in the Philippines. Thank you for watching. For more videos, you can watch this channel. For more content and online consultations, you can find us on lawyerphilippines.org.